bring up our next speaker, who is really the person that everybody in this room wants to hear about. This is an annual talk that we hear from Phil Eskew, who really knows the legal ramifications of DPC better than anybody in this country. And he's going to give those of you who've never heard this, information that you need to stay out of jail. And those of you who have heard this, he'll give you updates about what's new since last year. So Phil, come on up.
Okay. So here's your outline, which is also at the top of your packet. We're going to get into malpractice a little bit. I usually sort of shrug that off because it's not a unique problem to DPC per se, but it seems like there's more and more questions related to that as folks regain their independence and want to think about this for themselves. So we'll dig into that some. I'm going to spend much more time on dispensing today than I've ever done on any prior talks. A few updates from DPC mapper data you might find interesting. And then we'll go over some things that are happening at the state level and federal level. And the federal piece will actually be quite brief. This isn't the forum for sort of debate there, but it is an informational piece. Okay. So from a medical malpractice standpoint, what are the things you need to look at? We're going to go over deposition issues, peer versus expert kind of discussions, medical review panels. What does that mean? What if your state tells you they have that? Does that really help you or not? Malpractice caps, are those helpful and are they in place? And what are the rules around them? National Practitioner Data Bank, I think, is one of the most important pieces here, and there's a colorful piece of that on page 3 that we'll get to in a little bit. Curbside consults I've discussed before, but we're going to touch on that again. And then the Federal Arbitration Act is probably next to the National Practitioner Data Bank that most people are probably unaware of those provisions. The Federal Arbitration Act is pretty important too as you're drafting your contracts. Okay, so pointers from a deposition standpoint. If you are being sued, this is part of discovery and you are the defendant. You're not going to get out of the case at a deposition. You don't win the case there. You can embarrass yourself there. You can say something that's recorded there and act sort of indifferent because you forget there's a camera in the room and you're not looking at it, and they get to play that later at trial. This is their chance to catch you saying something you shouldn't have said or doing something you shouldn't have done, and even body language. So this is not your chance to tell your story. That's one thing I want people to remember. You do that at trial. You're not going to talk the plaintiff out or the plaintiff's attorney out of things at this stage. So don't give them sound bites. When it comes to the actual trial and jury selection, I'm guessing most people are like myself. You're a physician in this room, and raise your hand if you've actually gone through a trial and served on a jury. Okay, I'm counting maybe 5, 6, 7, maybe 10. Okay, higher than I thought it would be. Physicians often get out of it for various reasons, either due to work obligations or because you don't make it through voir dire. Almost certainly a plaintiff's attorney is going to strike you from the jury pool. So is it going to be a jury of your peers? Likely not. And it's often in your interest to avoid a trial by jury if you can, and that's where the Federal Arbitration Act comes into play a little bit later. So if you have a provision in your contract, and it might only need to be a few sentences that references the FAA, Federal Arbitration Act, then you can avoid a jury trial. And there are ways you can structure it to make that a little bit cleaner, but it's something that's been mostly overlooked in the DPC space, and it can help you out quite a bit. It's been enforced in many state courts, even when they didn't want it to be. And I can give you more on that later. Expert witness piece. Don't become a free expert. So this happens a lot when you have a patient who had a bad outcome, and they have no idea who really caused it, right? There was maybe a hospitalist involved, maybe their primary care doc was involved, and they saw 3 or 4 specialists along the way. So what happens is everybody gets sued. That's the process. You have to figure out who messed up so everybody gets named. And too often, everybody starts pointing fingers, right? You get in the deposition, you say, well, it's not my fault. I'm not the radiologist. I didn't read this wrong in the first. Don't do that. Don't become a free expert for them. That helps keep the case going even at times when it shouldn't. Okay. If you do start doing expert witness work, you've got to realize that you've got to have a strong stomach for that, because you're going to be the real bad guy. A lot of physicians are used to not liking attorneys. Who they really don't like is their fellow physician who's pointing the finger and saying, I think you messed up, and here's how, and here's why, and they give all that detail in the courtroom. If you do that kind of work, it gets recorded, and it's going to come up later at your own trial, should you have one. So you have to be prepared to defend that thing. Okay. And again, the multiple defendant problem is a real issue that I think most people overlook. Those kinds of things can finance an otherwise bad suit. If you have 7 different defendants that are sort of siloed off, they pay $5 grand, $10 grand to sort of settle things, and it keeps the suit going when it otherwise might have stopped had everybody been on the same team or the same employer. Okay. And of course, the caps apply on an individual basis too. So if you're in a state with a med mal cap of 1 million and there's 5 defendants, now there's 5 million at play. If everybody was under the same roof, there's only 1 million at play. Malpractice review panels, what do those do? What do those mean? They put provisions in place to have usually some kind of alternative dispute resolution. Whether it's arbitration at the state level, this is different from the FAA I referenced earlier, or whether it's mediation, and they're usually non-binding. They have lots of words in there that will sound like they're binding, but you get to the end of it and they're not. It's part of a procedural hurdle. So in my experience, these don't tend to change a lot of outcomes. In Wyoming, we have one, and I'll touch on that later. They basically give a recommendation, almost like an independent expert would, a sort of prediction of an outcome, but it can't be used in court. It's just a prediction that's made available to the plaintiff and the defendant to say, here's what we think here's what we think is going to happen. Do you guys want to settle this now that you have this objective opinion? Okay. And so there's the Wyoming piece. I got a little bit ahead of myself. I'm going to keep moving along so we can get quickly here. And here they tell you the panel's decision is non-binding upon any party. Where are the malpractice caps? So if you're in a red state, there's really no cap, and keep in mind these are only non-economic damages, so most people would think of that as pain and suffering. These are not economic damages, so those aren't capped anyway. Some states will tell you these make a big difference. Others, they don't seem to make that much difference in malpractice premiums, but that's there for your reference. And the other thing to note is that sometimes those caps that I just discussed only apply if you do certain things. And in 7 states that I'm aware of, likely a larger number than that, but at least in these 7, they only apply if you have malpractice insurance. Okay, so if you were foregoing it for whatever reason, couldn't get a good price, thought your risk was low, the state doesn't take that into consideration. It simply doesn't apply. If you have a PLLC and you think, oh, I've got this entity structure here, they can't come after my house, usually those aren't going to shield you unless you also have malpractice insurance. That's why a lot of states came up with the PLLC designation rather than letting you use a regular LLC, which would shield your assets if you had a cookie store down the street and somebody had a slip, trip, and fall on your icy doorstep. Not the case in medicine. And then you've got your 7 states at the top that flat out require malpractice insurance, no exceptions. And there's a typo there. Connecticut, of course, is CT, not CN. That's also in your packet. I must have been sleepy. Malpractice insurance, you got to understand occurrence versus claims made. If you have a claims made policy, that means that you need to buy a tail, because if and when you leave that job or switch practices and the claim shows up after the fact, then your original claims made policy doesn't cover it in that window and you would rely on tail coverage. Oftentimes these are tricks that a hospital system might have played with you. If let's say you're in the regular system now and you're debating switching to direct primary care, that's why I'm bringing this up. You got to go back and look at your employment agreement, and they often use that tail purchase obligation to sort of try to keep you from leaving. They might use that, or they might use a bonus that they paid you and then ask you to repay that upon your departure. You want to find an independent medical malpractice broker that actually knows about direct primary care, and at a minimum you should have volume discounts because your panel size is probably around 600 and it used to be around 2,000, 3,000, which is a lot greater number of potential plaintiffs. Never mind that you are doing probably a worse job since you're spending less time with everyone. Okay, and this is on page 3, so I'm going to jump through here and let you look at this. This second one is the more important one, so if you can pull that out in your packet. I think this is something people overlook when it comes to National Practitioner Data Bank. A lot of things can be placed in the data bank, and if a hospital is upset with you, this is one of the easiest ways for them to put a scarlet letter, so to speak, on your CV, at least in this system. When you go independent, there are different freedoms that become available to you. So the first 3 under the submit a report and the first 3 under do not submit, I think are worth highlighting. So it says, if the payment was made by an entity comprised of a sole practitioner for a benefit of named practitioner. So if you have your own DPC practice and you are the owner and there are no other physicians working with you and you paid it out in the name of the practice, then that's going to get reported. Okay? If you go over to the column on the right, do not submit a report if the payment was made by the individual practitioner out of personal funds. So let's say the damages were pretty low and it was $3 or $4 grand and you pay that out of your personal funds and not out of your business. Do you have to report it? No. So let's look at number 2. If a practitioner fee was refunded as the result of a written request, you got to report that. But if you waived a debt, so if they hadn't paid you yet, then you don't report it. It's kind of odd, but it's worth knowing. If a business entity comprised of a sole practitioner settles a claim, then you're reporting it. But if you formed a practice with more than one DPC physician and you settle it only in the name of the practice, then it's not reported. So those are details that I think are important. Curbside consult implications. If you contractually indemnify a third party, then you're exposing yourself to a new liability cap, and you're incurring a liability that may not be covered by your malpractice carrier. So I spoke about this last year with some third-party consult services that had indemnification provisions where you would use this anonymous specialist, and you weren't given their name, you weren't supposed to even tell the patient about them. And then if there's ultimately litigation that happens and the patient finds out and sort of discovers that and tries to sue both you and that party, now you've promised that you were indemnifying the company and or this nameless physician. So you've got to be aware of that when you're looking at those kinds of agreements. In Minnesota, thanks to a Warren v. Denter case, and in several other states that take this foreseeability of harm approach, you've got to be aware that that can extend your medical malpractice liability even more. So here the judge said a physician's breach of care is not excused by another's later breach. And what happened in Warren v. Denter was that you had a nurse practitioner who saw a patient who was probably a new onset diabetic. I don't have all the facts, I just have the limited amount that was in the judge's report. And there was a question about whether or not there was some sort of infection that was leading to sepsis. And this nurse practitioner calls the hospitalist, gives a presentation, and says, I think this guy might need to be admitted. And the hospitalist either doesn't hear all of this or sort of disagrees with the diagnosis from the nurse practitioner. That's unclear. But ultimately, the patient wasn't admitted, and the nurse practitioner wrote in the chart, hospitalist didn't want to admit, and also called the official collaborating physician and noted that the collaborating physician agreed with the hospitalist. Patient died. This was a Friday afternoon, of course, and the patient dies before Monday comes around, and the family's suing. And the family sued everybody because that's what you do when you're looking for data. You don't know who did it, so you sue everybody. And the local district court said, we don't have to worry about this hospitalist. He can't be a defendant in this case. Why? Because there's no duty, right? Any medical malpractice case, you got to prove 4 elements: duty, breach, causation, and damages. That's your classic torts case. That's what you learn, for a day 1 of law school. And there was no duty here because there was no relationship with the patient, right? This hospitalist might not have even known the patient's name. He didn't have the chart. All he had was what the nurse practitioner said on the phone. And on appeal, the court said, no, you got it wrong, district court. There was a foreseeability of harm here. And they said a physician-patient relationship is not a necessary element of a claim for professional negligence. A physician owes a duty of care to a third party when the physician acts in a professional capacity, and it is reasonably foreseeable that the third party will rely on the physician's acts and be harmed by a breach of the standard of care. Viewed in the light most favorable to the non-moving party, it was reasonably foreseeable that the patient seeking admission to a hospital would rely on the hospitalist's acts and be harmed by a breach of the standard of care, thus making summary judgment for the hospitalist and his employer and the element of duty, in this case, improper. Now, the stuff that they looked at on the books, you'd had a few cases where pediatricians had actually had this happen, where a child comes in with parents and the pediatrician maybe misses a diagnosis and says that whatever the condition is not contagious, and then later the parents get ill, and then the parents are suing over whatever this was. And in that case, at least you had some interaction between the physician and the patient, and I think there's a clear distinction. But here the court disagreed, and while it is a minority opinion, there are several other states that take this same approach. So when you combine these two concepts together, you need to be wary of how you use consultation services. And my general advice is here, and this should be in your packet too. I don't like the concept of license lending. I don't like it in the legal arena. I don't like it in the medical arena. I don't like it when an attorney tells you they drafted something and really it was somebody else. It was a paralegal or somebody else that did the entire drafting on a document, and all they did was glance at it. And I don't like it when physicians just co-sign a chart from a nurse practitioner or a PA and they barely looked at any of it and they don't really know what happened. You're lending your license and you're opening yourself up to liability, and you need to be aware of that. When you create silos, you make it easier for frivolous cases to come forward because they're less painful for the plaintiff's attorney. So if you're in a large group, act as a group, get sued as a group. Don't have each individual person have their own policy and each person gets sued individually. A true curbside consult's not going to be anonymous, it's not going to be compensated, and it's not going to be documented. That's what you used to do in the hospital when you were a resident, right? You had a tough case and you spotted the cardiologist walking down the hall and you said, hey, will you look at the EKG real quick for me? And you didn't throw him under the bus. You went by, you trusted him because you knew him and you worked with him, and that's your name on it, and you're weighing his opinion in what you do. And if the consult's anonymous, I don't think it means the same thing. If I know that Lee's really good at titrating Lantus better than anybody else in the room, and I go to him because I know him, that means more to me than picking somebody random in the audience and getting their opinion, right? So that's more defendable. Okay, how do I think hospitalists are going to respond to Warren v. Denter? I think they're going to start recording these phone calls. That way it won't be he said, she said. And they're going to limit their responses. They're going to be less helpful than they used to be. They're probably going to be less candid. They're either going to say admit or send to the ER because anything else might get them sued, which is not good for the patient. So Federal Arbitration Act, this I mentioned earlier, you want to reference it in your patient agreement if you want to avoid a jury trial. Enforceability is high even in states that fought it, you could do other things to make it even more enforceable. So you might offer a slight discount for people that agree to sign the one that references the FAA, and maybe you charge your full monthly fee to people that don't want to do that. So maybe it's a $1 discount or something like that, and basically everybody's probably going to sign up for this one. Charity care. So lots of states have Good Samaritan laws, and if you're volunteering, if you were flying here yesterday and somebody starts to have a heart attack on the airplane and you're assisting them, odds are you can't be sued for that. There are a few states that have bad Samaritan laws, which I found interesting. Minnesota, Rhode Island, and Vermont, there are certain situations in which you must rescue. So those are worth looking into if you happen to live in those states. If you're doing this kind of work on the side, you want to have a separate contract for this. Often your state is going to give you immunity from suit, and if your state won't do it, depending on how the clinic you're working in is funded, sometimes the feds will do it too. They don't use an immunity so much as provide you with a form of federal malpractice insurance. Go ahead and be public about this kind of thing. I've had other physicians tell me that when they volunteer routinely in the community, it decreases the chance that anyone brings a suit against them because now they get to reference all this volunteer work they're doing. And if you decide, this is kind of an interesting wrinkle, the third bullet here, if you decide you're not going to have insurance for whatever reason, maybe you barely practice and you've got a real small panel and you can't get anybody to give you a good price, go ahead and disclose that because it tends to deter litigation. And you're not allowed to disclose it at trial. That could bias a jury. And if you do disclose it at trial, if things are going real bad and you just decide you want to mistrial and you just raise your hand and say, I don't have insurance, the judge is going to hate you, your own attorney is going to hate you, and it's probably going to get you a mistrial and a new jury. So, all right, on to the fun stuff here. We're going to go to dispensing. This slide has a lot on it, and it's on the website, so it's not printed out in your packet. And we're going to walk through some of these wrinkles. If you're in a green state, go for it. You sort of get to build your own clinic and do exactly what you want to do, exactly how you want to do it. If you're in a red state, you really can't do it, and we're going to dig into those things in detail. If it's got a P next to it, it means a physician can dispense, but not a nurse practitioner and not a PA. If it's got an R next to it, then you have some formal registration requirement. And I'm probably missing some R's here, but I found all the ones I could and put them on. I've even got a few question marks because I've seen some documentation in those states that said a registration was required and then couldn't find the official documentation when I went to look. And that registration is hopefully with the Board of Medicine. That's who you would talk to first. Hopefully it's not with the Board of Pharmacy. That's who you would ask second. Never ask the Board of Pharmacy first if they can regulate you, because they might assume they can when they can't. Start with the Board of Medicine if you're not sure, and then ask the Board of Pharmacy based on what the Board of Medicine says to you. Okay, Utah's in orange because you can dispense if you have an on-site clinic, but not if you have a traditional DPC clinic. It has to be on-site with a large employer. Okay. So here's a little piece of trivia for you. What percentage of DPC practices dispense medications right now? Anybody know? This is data that I pulled out of DPC Frontier because now they can add these kinds of details in there. And it sort of surprised me, it's 50%. I thought it'd be a lot higher. Now, if you do some corrections and pull out the states where you really can't dispense at all, it's closer to 60% that dispense. Because you really can't do this in Texas, New York, New Jersey, Massachusetts, Utah, or Montana, as far as I'm concerned. And this was pulled earlier this year when there were 1,101 practices in the mapper. So what's going on in Texas? So kudos to Chris Held, who spoke earlier. She deserves a round of applause, and so does Dr. Michael Garrett. They're doing excellent work there. They've gone to the legislature several years in a row. There's been a big team of people that have been involved in that, and it's not passed, and it keeps getting buried. So right now, it permits non-controlled dispensing with some task delegation permitted to employees. This was their HB 1622, so they weren't even asking to dispense controlled substances, which is where a lot of the controversy comes in. They were saying non-controlleds only, and notify the patient that traditional pharmacies are an option, so it had some disclosures in there for patient protection purposes. The reason this got prohibited in the first place was due to abuses in the occupational medicine and workers' comp sector, where people were overcharged and they didn't really care because the workers' comp company was paying the bill. So we're trying to undo that. So this bill as written was going to require the physician to register with both the medical board and pharmacy board. I've highlighted pharmacy board in red because I don't think that was really ideal, but it was probably a compromise that they had. So what does the litigation actually say? So right now, Texas forbids physicians from dispensing more than a 72-hour supply of medications unless they work in a rural area, and they defined rural as at least 15 miles from the nearest pharmacy. So this is obviously irrational and it's not related to patient health or public health. And that's the argument that they're making. And here's a video that explains it. So you're going to see there's an Elite 8 coming up here. Physicians currently can dispense in Texas, only in those areas. So if you want to open a DPC practice in Texas, make sure it's at least 15 miles from a pharmacy. It's the first thing I would say to you. So you've got quirks like that on the books, and the fact that that exception is there sort of proves the entire rule is bogus. And so they're saying that this is imposing an irrational, oppressive, and protectionist restriction on the right to pursue chosen business, and it's drawing irrational, oppressive, and protectionist distinctions between similar situated groups. They are being supported by the Institute for Justice, and there's an attorney there named Joshua Wyndham, and I've been emailing him back and forth and asking him about this, and he's given me some timelines. I think, and I'm going to sort of jumping ahead a little bit, but you can make this argument in several other states as well. And he specifically wanted me to bring up Massachusetts as sort of their next target state. So if you're in Massachusetts, you can find the Institute for Justice. They're not hard to find. If you can't find them, email me and I'll put you into contact with Josh. But that's where they're probably going next. What about New York? What's it say there? No prescriber may dispense more than 72-hour supply of drugs, except for, and then they've got quite a laundry list of exceptions here, practicing in a hospital. There's some bias. If you dispense them at no charge, but if you bundle them into the monthly fee, then you get the insurance commissioner's attention, so that doesn't really work, and it wouldn't really fit the no charge argument. But then there are some exceptions that may prove useful to you. If you want to do an allergy-only practice or treat allergy and AIDS patients, you're good to go. If you wanted to affiliate, this is a more likely exception you might use, you might affiliate with a post-secondary institution. All of a sudden, if you do that, you're good to go. So this is another case where you sort of point to your state constitution like Texas and say, look, you're already demonstrating favoritism here and it's unconstitutional. New Jersey, you've got similar arguments. They try to limit you to a 7-day supply there, but there are exceptions if you practice in a hospital, an emergency room, a student health center, an institution of higher education, or a publicly subsidized community health center, or a family planning clinic. So maybe if you rename your clinic family planning, you're good to go. Who knows how they define it? So you can make arguments, I think, fairly easily following this Texas constitutional law argument in New Jersey and New York. Massachusetts, I think, is a little bit tougher. I'm glad Institute for Justice wants to take it on. But there, they don't have these same exceptions. The only thing they allow are free samples. And New Hampshire, similarly, doesn't have as many exceptions that would hollow out the rule. Utah and Montana, you probably could have a good action as well. But those already have broader exceptions that you could maybe work within. Montana, I couldn't figure out how they define the usual course of business. Maybe you could dispense to 49% of your patients. I'm not sure. So here's some random trivia on dispensing that might prove useful. So there are 6 states that restrict dispensing to physicians. Veterinarians or podiatrists or dentists. And what are those? Idaho, Kansas, Arkansas, Mississippi, Alabama, and Virginia. And what state requires physicians to register to dispense medications? So this is going back to that full map that we had earlier. Probably between 11 to 19, at least that group. And if you're not sure, where do you start? Board of Medicine. Not the Board of Pharmacy. Number 3, and this was kind of neat, just sort of stumbled across this. There's one state where you can dispense medications to patients that aren't yours. What have I just defined when I said that? That's pharmacist, right? So where can you sort of be a pharmacist? Virginia, in case that's what you're into. And that's cited on DPC Frontier. There's links to that. So Arizona, some states give you more specific procedures for dispensing, and others are sort of carte blanche, do it however you like. This is a fairly common procedural example, so I just put it up here. I picked them randomly. They want to make sure you label the medication. Even if it's not a controlled medication, they expect you to put it in a locked cabinet and for you to keep an inventory. And you're going to register with the board and pay a fee. And they don't want you to dispense opioids except for things like Suboxone and addiction therapy. And you got to disclose to the patient that it could have been attained at a pharmacy. This kind of stuff, if you're in a state where you can't find good regs, or if the Board of Medicine's kind of vague, you're not getting good answers, these are the kind of things you can just do as habit and get yourself some protection in the event of any investigation. So I've sort of tried to summarize things here, and this should be in your packet as well at the bottom of page 5. Dispensing summary guidance. So Georgia has my favorite manual. The state actually didn't require much, but they went ahead and gave out this nice, I think it's probably about 8 pages or so, manual of policies that they think would be helpful for you. And I think it is a good guide. So if you're looking for a place to start, that's where I would go. That's linked on DPC Frontier on the Georgia page. Most states, the fees are nothing or very low. Maryland is north of $1,000. That's the highest one I've found. And that's paid on an annual basis and sort of telling them that you're dispensing. Keep it as simple as possible. So some states start to restrict you when you get fancy, and fancy might mean repackaging the medication. So a lot of people in here use Andameds. Andameds sells lots of different medications, and often they're in quantities of 1,000, quantities of 100, 250. So my way to keep it simple usually is to not bother with repackaging these medications. Because when you repackage, especially in a state like New Mexico, you might have a different set of regs come on you. Now you got to deal with a $5,000 pill counter that you had to pay for, and you've got to, deal with this hassle. Instead, buy the bottle of 100 pills and dispense 100 pills. Put their name and instructions on it, and don't bother with the repackaging. It sort of saves you a lot of hassle. Makes inventory easy because you're getting your inventory from Andameds, and you can write the patient's name, and you've got your list there, and you're good to go. If you're going to dispense medications, I recommend you do it in person. There are states like Pennsylvania that I'm pretty sure require that. So if you've been mailing it to patients, that might be acceptable some places. It's not clear to me. That's often not addressed in state legislation. So I don't typically recommend you mail it. And in Pennsylvania, for example, at least when I did urgent care work there, it had to be you, the physician, had to physically hand it. You can't delegate that task at all. You might have somebody else counting out the medications, but you need to be the one handing it to the patient. Okay. So we're going to switch. Here's a little bit of DPC mapper data that I thought folks might find interesting. So Colorado is currently winning. I don't know if anybody here is from Colorado, but you've got more DPC practices than any other state. Florida, where we're at right now, has come in third. And you can see the rest of the leaderboard going down there. This I thought folks might find interesting too. Most practices are doing just DPC, roughly 90%. And we talked about dispensing earlier, about a little bit over half by my estimate. 85% are giving out their cell phone number, 95% are giving out their email, 70% make home visits an option, and discount labs are available 90% of the time. That's a little tougher in New Jersey and New York, and most folks are still doing some form of text message as well. Okay, so what about when your patient is leaving your office and they're encountering this mess in the rest of the system that we heard about earlier this morning? How can you help them out? Prior auths, don't play the game. I've mentioned this several times. There's a physician named Greg Zydiak who gave an excellent, quick 10-minute AAPS talk several years ago about how he deals with prior auths. He attaches this Gibson v. Medco case where a physician sued an insurance company and said, "You're making me do your paperwork. This has nothing to do with patient care. I want you to pay me money to do your stupid prior auth." And the insurance company just ignored him, and then he won in small claims court. So we have a victory there of sorts that you can reference. And the insurance company, at least whoever's handling this, won't have a clue what that means. So what you do is you take their prior auth, you put the Gibson v. Medco case on it and say, "If you want me to do this, pay me $45 and send it back to them." And so Dr. Zydiak did this multiple times, and he stopped getting prior auths. They just started approving stuff. Okay, so if everybody did this Monday morning, we'd be done with prior auths. And that's DPC or not. And the other thing you can do, I don't like this, but some practices will do this. They'll say, look, patient, you're asking me to do this. This is a lot of busy work. This medication is not that expensive. And if you really want it done, you could do it and sort of prove the point to the patient. That's not my preferred method, but some people do that. Tell your patients how to litigate their way through the system. And I don't know, I need to talk to them more. I think the health shares are probably already doing this kind of thing by necessity. But there are certain bills you don't want to pay. So don't pay that sticker price for the ER bill. If you're going into the ER, tell them, hey, I'm not going to sign your HIPAA form, I don't have to, and I want Medicare or Medicaid rates because I know you take those. And they're not going to sign that, but you're going to make that argument up front. You're going to tell them that whatever you signed in that ER was signed under duress. Okay, it's an adhesion contract, meaning one that you had no opportunity to modify, and it was signed when you were having chest pain, and you're looking at the STEMI on the EKG. This is not the time to negotiate. Okay, so after the fact, you get to take them into court and argue fair market value. How do you do that? You reference Medicaid rates that hospital accepts, you reference Medicare rates that hospital accepts, and you don't pay some astronomical price. You're going to win in small claims court. So make your patients aware of these things so that they do that. Okay, and then high tech, I sort of referenced a little bit there. I've talked about this in prior discussions. Let's see, we'll get into that in a second. So adhesion contracts, I sort of jumped ahead of myself. These things are easy to argue your way around, especially in a situation where there's duress. So use that to your advantage, use that to your patient's advantage. If you get a hospital that's dumb enough to say any of these things, especially in writing, please send it to me. You could have a lot of fun. So they don't have any say over whether or not they accept or don't accept a health sharing ministry patient. Those groups do not have contracts with them. Health sharing ministries are assisting the patient. And if they want to discriminate against them, good luck. They're not going to win. That's going to be a fun lawsuit for that patient. They might say you have to sign all the HIPAA forms, which is a misunderstanding of HIPAA, which is no surprise. It's commonly misunderstood. They might say that you have to use your insurance. Now, that hospital might have been dumb enough to sign an agreement with the insurance company promising they were going to force you to use your insurance, but I can tell you that your high-tech rights under a HIPAA modification say that otherwise, and federal law trumps private contract, so that's a lie too. We're not allowed to offer cash price below the Medicare rate. That's also bogus. Okay. Patient ER order operations, so I sort of talked about this already. The first thing they want to demand is high-tech privacy. So if they want to pay cash and not be subject to the false negotiated discounts under their insurance plan because all they need is a head CT and they haven't done anything toward their deductible this year, then they want to go in and say, no, you can't bill my insurance. I'm not giving you the right to do that. Under high-tech, I'm demanding privacy. Okay, so that's how they get out from under the $4,000 head CT for the head CT that you know should be $1,000. And then Medicare, Medicaid, they can reference that if they're arguing fair market value later in litigation. And this is the actual high-tech provision. This is in your packet. I've spoken about this previously, so I'm going to keep moving on in terms of time so we hopefully have some room for Q&A here. There's a model request statement. I drafted that little one paragraph there. I like to keep things short and simple in case everybody else you're interacting with says, who's this Phil Eskew idiot? He doesn't know what he's talking about. You can reference University of Chicago. They've got a much larger description there that actually they worked high-tech into their entire HIPAA document, which is great. I wish more systems would do that. Okay, high-tech privacy summary. So all covered entities must have a process for segregating this information within the chart. So when you make a high-tech privacy demand, you must be given a cash price. It doesn't have to be a good one, but they have to give you a cash price, and they have to silo off that information so they don't accidentally share it later, right? So if you've gone to the same hospital-owned urgent care 30 times, and on time number 31, for whatever reason you want to pay a cash price and you want to keep it private, then they have to put that aside, and then when they share things down the road under HIPAA, treatment, payment, and operations, they can share chart numbers 1 through 30 and 32 through 40, but not 31. And can most EMRs do that? No. Is that a HIPAA breach? Yes. Okay. So this is tough for hospital systems. They absolutely hate it, and I don't think they have a lot of good ways around it. The safest thing would probably be to put that visit on paper. As a DPC physician, do you need to keep this in mind? Yes, but it's unlikely it's going to come up because you're already not sharing information with your insurance company, because your basis for doing that was the insurance company paying you, right? That's the payment exception under HIPAA. But anybody who is a HIPAA-covered entity is subject to high-tech. Medicare patients can do this. It won't change the rate that they're charged. So whatever Medicare, whatever the CPT code is for that particular item, the same dollar sign applies to it. Medicaid, you can do that as well. HMO laws are state-based, and to the extent the HMO law at the state level contradicts the federal high-tech provision, the HMO law unfortunately wins. There was what I call a castration clause in high-tech on that piece. Okay. Here's where we are in terms of state DPC laws as of 2019. And that's available online for you too. The purple states, I would point out, have some official insurance commissioner guidance, and those are cited on their respective state pages on DPC Frontier. And this is what happened in 2019. So we got up to 28 states now with DPC law in the books defining DPC as outside of insurance. Hawaii, Maryland, and South Carolina all had efforts that didn't really go through. And I last looked at this about 2.5 weeks ago, but Minnesota and Wisconsin are technically still being considered, although I think Minnesota's is dead in the Senate for this year. So Arizona, they already had DPC law in the books. They were a yellow state previously, now they're green, because they really didn't sufficiently protect you from the insurance definition in their prior efforts. But now they've modified that. And I'm pointing this out here because it's a little bit different. They said specializes in family medicine, internal medicine, peds, or otherwise treats patients for chronic conditions requiring regular treatment, which I think is great. I'd like to see more states borrow that, because part of the concern as DPC expands is how do we really define primary care? And too many groups try and do it based on a residency category, and that's inappropriate. So any condition that's chronic and is treated routinely on an outpatient basis, it works great for. Georgia, no surprises there. They had great law that was passed this year. They had a 30-day notice provision, which I highlighted. That's common. Ohio snuck theirs through. Is anybody in the room from Ohio? And did you know about this bill? Anybody from Ohio and knew about this in advance of its passage? Me either. And I don't know exactly who did it. I'd like to talk to them. They did a good job. But I had several Ohio physicians contacting me after this law was in place asking about pursuing legislation. They snuck it into a 2,602-page bill. So it admittedly flew under the radar. The DPC provision was not that long, don't worry. It's just on page 1070 and 1071. So whoever did it, good job, but it'd be nice to know who did it. New Hampshire, they signed House Bill 508, and they notably mentioned workers' comp. They said you have to state that the agreement is not workers' compensation insurance. That's kind of uncommon, so just take note of that. It's not something that's routinely done in most DPC contracts. So the reason they brought that up, I'll go ahead and mention, is that some DPC practices were used to not doing anything on a fee-for-service basis. So you don't necessarily ask a patient if that laceration on their finger is a workers' comp injury, right? You just stitch it up and send them out. And some state workers' comp entities have a problem with this because then they view it as a non-reporting on the part of the employer. So you got to be aware of that. And I don't know of any state where you would have to itemize those charges per se, but you may have to write some sort of explanation that the employer can take back to the state workers' comp entity. Okay, New Hampshire also had a double dipping prohibition, which you like to see in your agreements. Okay, we'll keep going for time purposes here. So state not insurance summary, we've got 28 states. Oregon and Washington could still use some corrections. Washington, I do have green, but it was such an old law, and they've got a really aggressive insurance commissioner over there right now that they could use some corrections. 4 states have favorable guidance, and there are some lingering possibilities later this year. And this is in your packet as a reference as well. If you're in a state that's, you say, hey, there's nobody pushing anything right now, what do? I would start with Wyoming's legislation, and then I would go in there with this guidance too. The Wyoming legislation is really 1 paragraph. It's an easy read. You could fit all this stuff on 1 page, and that's sort of the point of DPC defining not insurance legislation. There were some pilot program discussions, and this is there for your reference too. I'm going to speed through these so that we'll have more time for Q&A. But Oklahoma, I do want to highlight. The rest of the states were giving it a go, but they did a bad job. And I wasn't disappointed that these didn't pass, except for Oklahoma. This is an early reference to the Michigan Medicaid pilot, which didn't go too far, and it had its share of wrinkles. Minnesota, a lot of commissioner shall statements, and when you leave that much discretion open, things can go wrong, and it turned into sort of a managed care discussion rather than a DPC discussion. So they're going to go ahead and set your fees. Not a good idea. And going to make you be available for 24-hour emergency treatment, which is a fundamental misunderstanding of what we do. Indiana, they had some price fixing as well. They had some arbitrary categories, formulary mandates, prior authorization mandates, which of course starts to smell like an HMO, which is not what we wanted. They categorized patients and limited you to certain categories. Said you were going to have to charge around $70. Have a contract with their office. Again, it's an HMO. They just didn't realize it. Missouri had some weird categories too. They were going to pilot it, but only if you were in a county with this size population. So I guess in Texas you got to move away from pharmacies, and in Missouri you need to move to certain sized counties. It's weird situations we have here. So we'll speed through that. That's there for your reference later. Oh. Okay, so she said they selected those counties in Missouri based on DPC practices that were already present, and your congressman happened to be a freshman and couldn't help you out there. Yeah, sounds about right. Virginia Medicaid pilot, they had a nicer effort, but it still had its share of wrinkles. Regular monthly fees shall in no case exceed $100 per month, so they were doing some price fixing. And there's a summary there. The data they were tracking I've highlighted in green because I actually like that piece. Why do I like that piece? Because they already have that information, don't they? That's downstream objective information that they weren't mandating from the DPC practice. So that's not problematic. Oklahoma. So if your state wants to pursue a Medicaid pilot, or what I would recommend first, a state employee pilot where they have even more autonomy, this is the kind of language they probably want to borrow from. So Oklahoma drafted it in a way that DPC physicians could participate without even knowing it. How did they do that? Because the reimbursement was with the member. It was with the patient. So they weren't going to pay more than $25 back for minors or $50 for an adult, and if they wanted to pick a practice that was a higher price, they could, but that was the cap at the reimbursement, so it's partially subsidized. And they said a sooner care, that was their name for Medicaid, member receiving reimbursement pursuant to this subsection shall immediately notify the authority upon termination of the agreement. So there's no reporting really coming from the practice. The burden is on the patient, since they're the one getting reimbursed. So they had a voucher reimbursement floor. Member notifies the authority. And the authority is going to quarterly do an invoice verification, and it's coming from the member rather than the physician. There's no price fixing. They picked an obvious floor that presumably had lower prices than any DPC practice because they didn't want to inflate the price by having too high of a reimbursement. Tennessee, this is also here for your reference. They just wanted to do a feasibility study. And Nebraska did have a state employee pilot, and it's a little early to know how that's going to turn out. It's going to be a 5-year effort from 2019 to 2023. The monthly fee is paid from the state, which I've highlighted in red. That could be problematic for obvious reasons. So if you're talking with the state and you want a sort of a summary for how to have those conversations, a voucher reimbursement floor is the easiest way to do it. Track downstream data, don't ask the DPC practice to give you data, and try to prove their efficiency by becoming inefficient. So there's the summary slide for you again, with various DPC state laws and pilot programs. And then this is the timeline. I believe I've got this in, I'm not sure if this is in your packet or not, but I can send this to you if you want it for another talk. But I think it's kind of neat to see how things steamrolled. If you go clear back to 2006, most people don't know it, but West Virginia was actually the first state to have a DPC law in the books. They didn't have the term direct primary care then, so it was often overlooked. And then Washington came in second. The original West Virginia law was terrible. It was designed to box in Vic Wood, who was a DO grad from my school, doing this up in Wheeling, West Virginia, and basically say, look, we really don't like what you're doing, but enough of your patients complained that we're not going to close down your practice. We just don't want you to expand it. And then later on, they had a corrective law in 2017, so West Virginia now has great law in the books. Okay, so that's there for your reference, and you can sort of see how things increased. I guess 2015 and 17, for whatever reason, were the largest years in terms of expansion of DPC defining not insurance law. Okay, at the federal level, this is an executive order timeline that I think is worth having there as your reference. So several of these things were ancillary and downstream to DPC. HRAs, short-term, limited duration insurance plans, association health plans, all those things were modified with executive orders, and those are in various stages of litigation. The HRA rule is the one that's the most important for our purposes, in my opinion, and it hasn't been litigated yet. So federal subject matter updates. 213D and 223C, I'm so tired of referencing these provisions of the tax code. 213D is where the IRS defines what is a medical expense. And the IRS doesn't understand DPC. They've said this in multiple letters from Koskinen and others. And so they're not sure if it's a medical expense, even though we all know it is. And they have a very, very weak argument otherwise, especially with the new CCM codes that are out and can be almost an argument for, that that's what we're doing. So they're, even though we don't need it or want it, there sort of is a code for what we do. And it's clearly a medical expense in my opinion. The HSAs, health savings accounts, HRAs, and FSAs, flexible spending accounts, they all reference 213D. Okay, so if you want to fix the problem so that you can use those accounts, you need to fix 213D. HSAs also reference 223C, which is your gap plan problem, and that is a separate issue where the IRS says, okay, never mind the medical expense problem. If we just look at this DPC plan, even though it's not an insurance plan, it's a type of other plan under the tax code, and it's a $0 deductible other plan, so now you're no longer eligible to have an HSA because you're a DPC patient. Also a flawed opinion. So that has been discussed routinely at the federal level, and if you follow the debate, there's been some disagreement about how to go about making those corrections. Everybody wants the same thing. There's just a different legal and political strategy sometimes about how to get there. Medicare pilot discussions have been held as well. Those, I don't even remember if I have them much in this talk because they haven't gone very far at all. And there have been discussions about opting out and doing modifications to that process, which is currently on a 2-year rolling basis where it automatically renews. And then what I wanted to bring up, because I haven't seen it discussed anywhere else, is the discussions around civil monetary penalties updates. Okay, so here's the timeline on 213D and 223C. Original letter came out in 2014. It was a bipartisan senator and representative letter to the IRS, and Koskinen said, no, go pass a bill. Only 13 days later, which I was surprised it was that quick. And in 2018, repeat efforts were made, this time a letter from Cruz and Johnson, and the IRS said the same thing, go pass a bill. And then we had another letter in January 2019 from Doctor Patient Care Foundation to the IRS, and then a subsequent White House executive order, which we'll get into the text of a little bit later. And then we have HR 3708, the Primary Care Enhancement Act, or a new version of it, which has some flaws that are being debated. So the executive order in June 2019, this was the DPC provision from that executive order. So I've got some things in bold, I've got some things in red that are concerning to me. So within 180 days, so it's coming up, the Secretary of the Treasury, to the extent consistent with law, which to me opens it up for debate, shall propose regulations that potentially could include direct primary care and, oh, by the way, health sharing ministries as eligible expenses under 213D. So we'll see if they do that or not. I certainly hope they do, and I certainly hope it holds water. I don't think the IRS has any appetite for litigating this because they would lose. But the problem is they've left it gray because gray is to their advantage. Because they're, from their standpoint, they don't want HSAs to grow because that means less tax revenue. And the grayer they keep this, the more problematic it is because you and I have to spend hours explaining this to a patient with an accounting background or to more likely an employer who wants to work with you and is now being told by a broker or someone else, hey, you can't do that. So we need to end this discussion because it kills your elevator pitch. Some Primary Care Enhancement Act summary, it does correct both 213D and 223C. The House version had some problematic restrictions, and I can get into those later, probably not in Q&A here because we want to focus on other things, but I can talk to you one-on-one on it. The primary care only restriction is an issue. I think there are workarounds. The $150 a month restriction is an issue. It's supposed to go up over time, but right now they've put that in the definition of DPC. This was not in the original Primary Care Enhancement Act. It was in the version that passed the House last year on a bipartisan basis, and it is in the current version because that was the only way Treasury said they could score it. They said that you shouldn't bundle in meds, labs, and any procedures requiring general anesthesia into the monthly fee. So as long as those things are itemized, they could still be offered with the practice. That's my legal interpretation. Medicare pilot discussions, these are currently gone quiet, and the ones that were proposed were quite lousy. They borrowed the term DPC and changed it to something else, and then when we complained, they changed it back to DC, which I like to joke makes sense because that's where the idea came from. Opt-out modifications, those have been discussed as well. I don't predict any of these in the near term, but if Medicare were to ever try a DPC pilot and they wanted to work with DPC practices, they need to come up with a way of addressing the opt-out issue and allow you to do that even though you've opted out, is basically how they would have to draft it. So this is what I wanted to spend a little more time on because I don't think anybody's discussed it. There have been discussions about modifying the civil monetary penalties law. So there's your citation, this is in your packet, and the long and the short of it is, you might say to yourself, hey, maybe I don't need to opt out of Medicare, maybe I could just do the CCM monthly billing, which if they have 2 chronic conditions pays me $82. I can document my time and not do any fee-for-service coding and just take the $82 and call it good. What's the problem with that? So under civil monetary penalties, that becomes an unlawful inducement when you did the EKG and you didn't charge them for it. The government says, well, hey, you're just doing that just to get them to sign up for your CCM stuff, and then you might be abusing us over there. So if you're in Medicare, you don't have the opportunity to selectively bill for some things and not others, as the law currently stands. But there's proposals to change that. So this is their definition of remuneration right now: transfers items or services for free or other than fair market value. So that's the situation I just described, where you would just selectively not bill for a lot of fee-for-service stuff that isn't worth your time. Okay. So any practice permissible under the anti-kickback statute, whether through statutory exception or regulations issued by the Secretary, is also accepted from definition of remuneration. So they've got a few that are already accepted, and this is there for your reference. So don't hold your breath on these, but this is what they've said in their proposed guidance. This is a quote. With respect to fair market value requirement, we might remove it entirely. We might remove it only for monetary remuneration or other in-kind remuneration and so on. We might permit a broader set or free or below fair market value arrangements for those that are coordinating care in an underserved area. And then they said, well, we're concerned that it could result in steering or unfair competition, so they're kind of waffling. So we'll see what comes out of this, but it's an unanswered question, and right now it's a proposed rule that's going to be made a final rule at some point. So this is where the math works out if you were going to do something like that, and again, you got to be very careful. But if you use the 99491, it's $83 a month most places, and you're talking about a charge of $996 a year, and $347 of that is out of the patient's pocket, and the rest is paid for by Medicare. So even though Medicare keeps talking with DPC physicians and totally messing up the proposed pilots, they've got this potential for an indirect pilot they weren't even considering. But the devil is most certainly in the details. If you were going to do that, these are some of the other codes that you might use to basically replace your initial visit fee. So your enrollment fee would be around $300 if you just routinely did those codes, because they're things that you would probably automatically do with any initial visit anyway. Again, I'm not excited about this, but it's worth pointing out because it's going to be discussed. Okay, so here's your summary. It might affect people's opt-out calculations, especially as they're initially transitioning to DPC. If you stayed in Medicare and you participated in this, you'd have to be very careful that they didn't change the program at any point, and you'd have to remember that Stark and anti-kickback laws fully apply since you're participating. And you wouldn't have freedom to change your monthly price. Okay, so federal summary here. If you're going to privately contract with a Medicare patient for covered services, then you need to have opted out. If your patient or their employer does not have a tax concern, then it's not your job to police the transaction. This tax status is taken by your patient, not you. So it's their call with their accountant what they want to do. If they agree the audit risk is low, it's up to them. If your patient or their employer have tax concerns, then you can charge on a cash pay fee for service basis that approximates what you're doing in DPC, and it could satisfy their concerns. It's a little clunky, but it's the workaround that we currently have. At the state level, consider any DPC law that's already in place. Start with that. If you don't have it, you could push for it. You could, and at this point, we've got the majority of states with it on the books, so it should be less and less difficult to get these things passed. If you have a dispensing problem, be aware of that and attempt to fix it. If you're going to do a Medicare or Medicaid or state employee pilot, reference the Oklahoma language. And if you have any questions, there's my email. Hopefully the packet's useful. If we still have any time, I could do Q&A.
I'm just going to tell you, having done this for a long time, the question you sort of got to that you can undercut Medicare pricing on a cash arrangement. We hear this all the time from specialists. Can you give us a cash price on this? And they always say we won't, or we cannot undercut Medicare. You said you can. Can you tell me in a context of how they might be able to do that?
So that was modified. I don't have the reference off the top of my head, but I could find it and get it to you. I think that was modified in 2008 or 2009. Medicare realized that they were messing over cash pay patients. So that provision is just outdated information. You are allowed to charge a price less than Medicare, and you are allowed to charge a price less than Medicare to a Medicare patient when they invoke their high-tech rights. Now, if you're participating in Medicare, you can't charge a cash price higher using that high-tech exception. But, yeah.
Chad?
Phil, fantastic talk. You have a really
Thanks,
weird
Chad.
hobby, my friend. So,
Yes.
But thank you for it. Under the ER, getting the good prices in the ER, you mentioned reference high tech, and then you said on anything they sign to put that they want the Medicare rate. Are you literally saying in the margins of
Sure.
any contract, something, and that would hold up? Just say, I want Medicare.
It builds your argument for later. So what the hospital is going to say is, hey, we didn't agree to that, because it's designed for one person to sign, the patient. But it tells them up front, hey, I didn't want to use insurance, I was using high tech, and I wanted a price that I think is fair. And you're allowed to reference that with a judge. Unless you've managed to find a hospital that doesn't take Medicare or Medicaid, it's a strong argument in the patient's favor.
So maybe put, I'm referencing high tech, I want Medicare, sign name. Great, thank you.
Microphone 1.
Yeah, I have a question about HIPAA. So let's say you have a direct care practice of any type and some of their patients are insured and that direct care practice does not bill or transmit any data to any insurance company, but they do transmit, let's say, a diagnosis code to Quest, who then bills the patient's insurance. Does that make that direct care practice need to be under HIPAA because they transmit that code to someone else who will then use it to bill insurance? And just a discussion on that. There may be no answer.
I think what I usually tell people is you can start to build an argument that you're not a HIPAA-covered entity if you don't electronically transmit information in connection with payment, which is how it's, point blank defined. But I wouldn't go to bank with that, There's probably, there's going to be state privacy laws at play anyway. So if you can build an argument that you're not a covered entity by taking that step, which is what you're going down, I would do it. But then in the alternative, go ahead and prove that you're taking patient privacy seriously. I would go ahead and have your HIPAA notice of privacy practices and those kinds of things in place anyway.
So we do have a few more minutes. Microphone 2.
Phil, thanks for your help with the New Hampshire bill. You mentioned one of the pain points interfacing with patients' insurance with the prior authorization. The other one is the HMO plans requiring a network PCP to do referrals to specialists. Maine just passed a bill over the last couple of years modifying it to require them to pay specialists when they're referred by DPC physicians. There's some certain circumstances. Are there other states that have similar problems? Do you have a suggestion for how we can approach this major pain point as well?
HMOs are terrible. And they were written, it's fascinating to me that these laws were ever passed. They were federally encouraged, so a lot of them are very, very similar from one state to the next. And they've got the middle finger up to the rest of law in the books because they are an exception to CPOM, corporate practice of medicine, which usually is used by a physician to tell, theoretically, a hospital CEO or anybody else, you can't tell me how to practice, that's unlawful. But HMOs are literally allowed to tell physicians how to practice. And they're allowed, in every state, maybe except Maine, as far as I know, to totally dismiss orders that aren't from somebody credentialed in their network. And you would find the same thing, theoretically, in Medicare and Medicaid. We just don't realize it. So when you opt out of Medicare, you're still credentialed with Medicare. If you'd made Medicare mad and you didn't opt out and instead you got kicked out, now even though you're running a DPC practice, you've been kicked out, they don't no longer recognize your degree, basically, and any order for home health or medications or whatever, they're not going to honor. So I'm impressed that they passed that law. I would also be impressed if a court enforced it, because they've usually had deference to this HMO law that's well established since the 70s. And unfortunately, my main way to recommend pushing back against an HMO isn't necessarily legally, it's politically. In that especially if your patient's willing to go public, you can embarrass them in a lot of ways with what they don't approve. I mean, the news stories are happy to take those kinds of articles.
Microphone 1.
Phil, thanks as always. Great overview. I have lots of questions, but the one that I think I'd like to answer the most has to do with the charity care provision that you sort of discussed, is that having a separate agreement for charity care. And one of the benefits of taking the reins back is that we can make exceptions potentially, and for times of financial hardship, the most vulnerable patients. And so I don't know if you want to clarify that. I don't know if there are practices out there that have a template for that, but
So you would take your normal agreement and I would just modify it slightly to make it clear that it is charity. And if your state has some law on the books that says if you do X, Y, and Z, we're going to deem you charity and ergo you're not liable from a malpractice standpoint, then from your medical malpractice carrier's point of view, your panel's now smaller, your premiums are now lower. Okay. So especially if you're later in your career maybe and you've got a panel of 600 and 300 are paying you and 300 are charity because that's what you want to do, then that ought to cut your malpractice in half, right? So by having a separate contract, by separately listing those things and by referencing whatever protections are on likely the state law for you, you can do it that way. If you go through all the hassle of qualifying federally, then they'll cover your malpractice in that setting.
if somebody loses their job temporarily, you're suggesting having it as part of your primary agreement as a practice, but if somebody needs an exception for a few months, would you have them sign a separate agreement at that time? Or just like you said, bundle it in as a separate clause?
I mean, if it's only a few months, it might not be worth your hassle, okay?
Right.
But if it's going to be an ongoing thing, I would certainly do that. The thing you triggered in my mind when you said lost job is COBRA, which people need to be aware of. If the employer was paying the bill and now the patient has to pay it, and oh, by the way, I don't have a job and I want to keep coming here, how am I going to pay you? So yeah, you could find yourself in a COBRA situation where you have to offer it to them, and it has to be offered to them at the same rate the employer was paying you. And then if they say they can't pay it and you want to do charity, you can. Yeah.
We have time for one last quick question.
Yeah, I was just interested in the Oklahoma example of them reimbursing at the patient level. I'm wondering if there's any way they do that through a tax-free vehicle, or are they just using that as taxed income? Because it doesn't seem like they can do it through an HSA, HRA, or FSA.
I don't know that they even contemplated that part. I suppose, off the cuff, I would think you would still be eligible to use all those things because this reimbursement's coming from the state. And it probably isn't going to pay all the monthly fee. So to the extent it didn't pay, I would think you could use those vehicles. But I don't know. That's a good question.
So, first of all, I want to thank Phil for his friendship and his expertise. Phil has always been a great friend to the direct primary care movement, and he's always been very free with his information. And I'll tell you that Phil flew from Wyoming just to be with us for this morning and is flying back out. So, thank you.